Do you have a workers' compensation claim and you want to know what's going to happen at the end? Am I going to get to go back to work? Are they going to fire me? I want to know what to expect. Well, stay tuned. In this video, I'm going to go through the ins and outs of what to expect regarding your job at the end of the workers' compensation process. Hi, I'm Naomi from Gonzalez Law. Today's topic is what will happen regarding your job when your case is done. There's two scenarios here. The first one is you're able to recover all the way back to normal or close enough to normal so that you have no permanent restrictions. If that's the case, normally you would go back to work. The exception is there are two types of settlement. If you decide to go forward with a compromise and release, that type usually does require a voluntary resignation, which means you would no longer be able to work there. But if you want to work there still, then you don't have to accept a compromise and release. You can go ahead and go for the stipulation with request for award. So just make sure that you are able to continue working there after the case settles. The second scenario is you're just not able to recover well enough to work full duties. In that case, the doctor will assign you permanent restrictions. These permanent restrictions are there as a guideline so that you do not do something to injure yourself more. At the point that your primary treating physician or the QME, the Qualified Medical Evaluator, gives you their final report, your employer has 60 days to do an ADA assessment, Americans with Disability Act assessment. This is because now that you have these permanent restrictions, you now fall under the ADA law as to a person with disability. This should be not just a, nah, I can't accommodate him. No, this should be an interactive process between you and the employer working together to try to find a solution here. The first thing that happens in an ADA assessment in the interactive process is they take a look at the job you had been doing before your injury and at your permanent restrictions. And they say, can you do this job with these permanent restrictions? If the answer is yes, then you should do that job again. Go ahead and go back to work. If the answer is no, then they look at it and say, okay, can you do this job if we provide reasonable accommodations? Now, the ADA reasonable accommodations is kind of a broad term, but usually it's something that the employer can do that does not have undue hardship on them. What we normally see as a kind of reasonable accommodation is either modifying equipment that you can use, modifying your duties or schedules. Things like that are usually things that can be modified as reasonable accommodations. So they look at the job and say, can you do these with reasonable accommodations? So for example, let's say your restriction is you cannot lift over 50 pounds, 50, and you are an office worker that just types on the computer all day. Well, in that case, you should be able to do that job within those restrictions and you go back to work. No need for reasonable accommodations. Now, if you are a mover, then there probably won't be able to do a reasonable accommodation that will allow you to move. However, if you work in a warehouse, maybe like an Amazon or something like that, and they have the jobs that are separated by heaviness of items, they might be able to put you in a department that only does up to 20 pounds or something like that. And you maybe can modify your duties that way. So it really is a case-by-case basis, and that's why it should be an interactive process to try to find a solution. So if the answer is no to you can do your regular job without accommodations or with accommodations, and the answer is no to both, then the next question is there a job anywhere in this company that you're qualified for that you can do without accommodations or with accommodations? So if they're trying really hard to get you in a position, but there just really isn't anything out there, then the answer would be no. And there's just no way to physically work there anymore. In that case, you would no longer work there. They would not offer modified work, and you would be eligible for a retraining voucher. If they are able to place you, then they should be giving you an offer of modified work and you should start back to work. The retraining voucher is a SJDB voucher, and that voucher will be worth up to $6,000 for retraining purposes. So whether that's a vocational school, maybe that'll teach you to start being a truck driver, maybe a medical assistant, maybe whatever you want to do. It can be put towards university if you're working towards a degree. There's a lot of different uses. I personally think that the voucher is way insufficient because lots of times what people want to do to change careers is going to be more than $6,000. However, that is the current law system. That is what the workers' compensation system allows for retraining for people who can no longer do their job because of their work injury. And this is all general information. If you would like information specific to your case, give us a call or text us consult, and we'll be very happy to talk to you about your case.